All right, we'll call case number 2018 CF38, State of Wisconsin versus Beatrice Bender. Let's see. See Mr. Verbatim. I see Ms. Parent. Ms. Parent, is your client somewhere?
Your Honor, she is not here. I did send her a note and told her that I was feeling a little bit under the weather, so I thought she should appear from another location. But I don't know that she's on the line.
Yeah, I see a Tammy Burke. I see Ms. Miles from the crime lab. And it looks like a deputy on the sheriff's department. So I don't think it's an evidentiary hearing, but maybe it is. What do you suggest we do, Ms. Parent?
Your Honor, I mean, I don't know what Ms. Bender would say about this. I don't know. I don't have any information from her. I think, to me, this is not an evidentiary hearing, but the state has a lot of witnesses. So there may be some dispute on that point. If it was not evidentiary, I would say that I think it would be okay for me to waive her appearance.
All right, maybe what we should do, the best course of action, maybe you could mute and maybe give her a call since you have some good contact with her, and maybe she's having problems getting into the Zoom session.
Okay.
All right, let's go off the record then if you don't mind doing that.
Okay, I'll do that. Your Honor, I was able to leave a message for Ms. Bender, but she didn't pick up the phone.
All right, okay, we'll go back on the record. Ms. Parent left a phone or a message for her client. Was unable to get a hold of her. Mr. Verbatim, what did you want to do?
Sorry, Your Honor, I was on mute.
That's okay.
Your Honor, my experience is typically a defendant, Ms. Bender in this case, is present for any and all hearings. And while I understand that there's a question about whether or not this is an evidentiary hearing, I thought important to have witnesses subpoenaed in case the court felt it necessary to receive additional evidence beyond what was contained in the four corners of the complaint. Thank you.
So then what is your request here today to do?
If Ms. Perrin believes that it's necessary for a client to be here for the hearing, then I guess we'll have to adjourn it. Otherwise, the state's prepared to move forward.
Okay, so you're not requesting a warrant or anything?
Your Honor, Ms. Perrin was indicated she'd spoken with Ms. Bender, and I think even today, and suggested she not appear at her office because Ms. Perrin was feeling under the weather. Well, certainly it's my expectation, and I believe the court's expectation, that people appear for Zoom appearances. I'm a little uncomfortable asking for a warrant given how this has played out today.
All right.
Can I
And
just,
I mean, I'm not saying I would have issued one, it just was, I just wanted to boil down where you were coming from, because then at first you say, they need to be at every hearing, which I agree 100%. So I didn't know if you felt like I should issue a warrant to make sure they're here or not. That certainly clarifies it. Ms. Perrin, if this is a non-evidentiary hearing, are you willing to waive your client's appearance?
well, I'm a little confused about whether it is or not. So that's a little bit of a concern. Yes, I think I would be, but I want to clarify the record that I did not talk to her today. I sent her an electronic message telling her that I was not feeling well and I thought she should appear from a different location. I don't know if she got that or not.
Okay, I mean, clearly we sent her notice of hearing, so I don't think that's up for any type of debate, unless she's changed addresses, but it didn't come back in the file, so it's certainly there. As far as this motion goes, I would be inclined to proceed with the motion. I feel like it's not evidentiary, but maybe if it turns into evidentiary, we can adjourn it to allow that opportunity. Ms. Perrin, then let's proceed with your motion.
Your Honor, there are two motions. One is a motion to make more definite and certain as it relates to the bail jumping charges. And it's, on that motion, it's a pretty simple request. I don't believe the state due process allows the state to say, well, there's a variety of things that we could prove, and we're just going to throw it all up against the wall and see what sticks. I think that the defendant, under her due process rights, is that it's fair to tell us what exactly the bail jumping allegation is. Then, second of all, is the motion to dismiss the OWI charge. And with that charge, I would note that I don't think the state is even able to name a substance that they think that Ms. Bender could have been under the influence of. And other than that, they simply have no proof. The blood test came back negative. And like I said, it's a mystery substance, apparently, if they're going to go forward, and I don't think they can go forward on that basis. Again, I believe that the law requires that they tell us what they think she's under the influence of.
All right.
So we would ask the court to dismiss that count.
So I just want to clarify what I think can frame the issues. It's my understanding that the state's saying the bail jumping is committing another criminal offense. Is it your position that they need to name the specific criminal offense they're alleging was violated by the bail jumping?
Yes.
Okay, Mr. Verbatim.
Your Honor, I guess that it's clear to me, at least from the state's perspective and in the state's response, that it's that she committed a new crime. And if the jury, I guess, if the court, or excuse me, the defense wants us to be more explicit, then the reality of it is we would charge a felony bail jumping for each allegation in the complaint. So that would lead to a number of charges. And I think that at trial, then we're alleging that she committed the crimes of OWI, possession of illegally obtained prescription, 3 counts of that. So that's 4 counts. I think it's pretty clear how we're alleging that Miss Bender violated the terms of bond and she committed a new crime. Any one of these, the jury can find that it's not hidden, it's in the complaint. And for all those reasons, I would ask that the motion be denied. If the court chooses to require a more definite statement, I would seek leave of the court to amend the information and allow the state, if it so chooses, to allege a felony bond jumping for each alleged new crime. So that would be, I think 16, because there's 2 different felony bonds and 4 allegations of misdemeanor bond jumping. Thank you.
Just in a question to follow up on that, I don't know that it's an issue for this motion, but assume that I find that there's no reason to give a more definite statement, and quite frankly, the allegation of just alleging another crime is fine at this stage of the proceedings. The question I have ultimately that came to my mind is, how does that implicate a unanimous verdict? Are you going to have to, or in jury instructions, list the specific crime? Have you looked into that? And what's your position, maybe too quickly, what's your position on that, Mr. Vervaeten?
Your Honor, if this were a party to the crime question, I would know the answer right off the top of my head. There's unanimity as far as a theory of party to the crime. It doesn't have to be. I would have to research the issue of, do they have to be unanimous as to which crime? Off the top of my head, it seems like it would require unanimity in that they would agree on which crime was committed, thus the bond violated. But I would have to research that issue to be sure. But I think common sense tells me they'd have to have unanimity in the crime.
And I'm not sure either, but I kind of agree with you. With that being said, this motion just becomes kind of moot, because at some point you're going to have to give your theory, and on a jury instruction and verdict form, or at least on the instructions, give the specific crime that you want them to find on, I'm assuming. So do you think it makes more sense that you amend the information to do that? Or do you think, in your opinion, you would just like to proceed as is and we deal with it at instructions and verdict?
Your Honor, I think to avoid confusion with the jury and wondering why it's this crime versus that crime, it would make more sense to amend the information and allege a bond jumping charge for each count with regard to each bond that's been violated.
Ms. Perrin, does that answer your issue or your question then? we don't really need a more definite statement. He'll amend the information just to allege a bail jumping per each crime he believes he can charge or he can convict.
I'm sorry, could you restate the question again?
Does by him amending the information and he'll allege a specific crime for each bail jumping, he's just going to add in more bail jumpings. Does that answer your question of request for a more definite statement?
Yes, it would.
Is there any objection to amending the information to allow him to do that?
No.
All right, I think we've dealt with that issue, Mr. Verbatim. When can you have that done by?
Your Honor, due to the holiday, I would ask, because I know my staff, I'm off most of next week, all of the following week. My staff is off next week. I would ask until January 8th.
That seems more than reasonable, Mr. Verbatim. Ms. Perrin, any problem with him making sure that's done by January 8th?
No.
And it is okay then, when did your client, and I think your client just joined now, so that's good.
She did.
When did you want her to appear then on that amended information? Did you want to wait until the pretrial conference, or did you want to try to do it sometime sooner?
I think we could wait till the pretrial conference.
Is that okay with you, Mr. Verbatim?
Your Honor, yes. And that raises well, I'll talk to Ms. Perrin about the other issue with regard to whether or not the information needs to be amended. Thank you.
All right, and then the next issue that we're addressing is the motion to dismiss regarding, and I think I'm going to try to frame this one correctly too. Regarding the motion to dismiss, my suspicion or my opinion is you're basically saying, I mean, if there's enough in the complaint, I guess what you're saying, Ms. Perrin, there isn't enough in the complaint to support probable cause?
I'm saying, Your Honor, that the complaint isn't specific about what substance the officer believes that she is under the influence of. Then, you know, I think it does change a little bit with the drug test results, and I think it's fair for us to bring this back as a probable cause challenge, because that even emphasizes further that the state cannot name a substance that they think Ms. Bender is under the influence of. There's also other issues related to the officer's statements about, you know, his suspicion that she was under the influence, that we certainly could challenge. But, you know, and I suppose that's where an evidentiary hearing would come into play, would be the officer testifying about his observations in relation to probable cause. But I would still argue that none of that necessarily even matters if the state can't allege a substance. I don't think the state can say that, well, we don't know what it is, we just think she was. You know, I don't even know what that means. So I would argue, as a matter of due process, that they can't go forward with the charge if they can't allege that she was under the influence of a specific substance.
Mr. Verbatim, your response.
Thank you, Your Honor. Your Honor, I'll note, first of all, that this is not a complaint wherein Ms. Bender is also or simply charged with, for example, a prohibited alcohol content or operating with a restricted controlled substance. If it was a prohibited alcohol content charge, surely the state would have to have evidence of what that level is. Similarly, if this was a charge of operating with a restricted controlled substance in her blood, the state would have to allege what that restricted controlled substance is. That's not this case. In this case, the state is alleging that Ms. Bender was under the influence of, and I'll get the language correct here, of an intoxicant, a controlled substance, or a controlled substance analog, or any combination of those. We have the information in the complaint of what Deputy Aaron did. In other words, the field sobriety test that he administered and his belief that she was under the influence of a intoxicant, controlled substance, or a combination thereof. And for those reasons, Your Honor, I would ask the court to deny the motion. In fact, Deputy Aaron, who is a DRE, stated that he believed she would be under the influence of a stimulant like methamphetamine or THC. Furthermore, Your Honor, the question of whether or not she's under the influence is a question of fact for the jury. And I think there's sufficient allegations in the complaint to meet the minimum requirement in the four corners of the complaint to move forward. Thank you.
Thank you, Mr. Verbatim. I have reviewed the criminal complaint. I think the criminal complaint does give probable cause and does allow enough evidence for the state to proceed on their theory. I think that Ms. Perrin's issue is noted, but I think that's an issue that could potentially be brought after the close of evidence if there isn't enough evidence to be brought to the jury in order for a reasonable jury to convict, but we're not there yet. When I look at the criminal complaint, I see all sorts of information about the horizontal gaze nystagmus, other sobriety tests, and ultimately, the deputy's opinion that
Your Honor, can
he
I?
believed that the defendant was to be under the influence of a stimulant like methamphetamine or THC. Again, ultimately, maybe that's true or maybe that isn't true ultimately, but we're at the point where we're challenging the complaint or the ability of the state to move forward on charges. And for me to now already be the fact finder and make a determination about whether or not there's enough evidence based upon the complaint, in my opinion, the four corners of the complaint give the state enough evidence to proceed. That being said, my concern, again, about is the unanimous jury. So in the information, which is now the formal charging document, it does allege, as Mr. Verbatim said, the different, under the influence of an intoxicant, a controlled substance analog, or any combination of an intoxicant, a controlled substance, and a controlled substance analog. So my question again becomes, isn't there going to have to be a unanimous verdict? Maybe or maybe not. I haven't done the research on it. But my concern is when there's all of those in the alternative, I don't know that we always have a unanimous verdict. So at some point, the state, when they're presenting their evidence, may need to make a determination on what theory. Ultimately, this idea that there has to be a choice of a particular controlled substance or intoxicant, I don't think there has to be. I think a reasonable jury doesn't, a finding that is made by the jury and in the verdict or instruction nowhere does it say that the jury has to make a specific finding on an intoxicant or a controlled substance or otherwise. And I think the burden, it creates a burden on the state that is non-existent under Wisconsin law. So at this point, the motion to dismiss the operating while intoxicated is denied. But again, it's something that when you're looking at the evidence after the presentation of the state's case, I could see a similar motion being made. And also, I'm very cognizant of whether or not this is going to be a unanimous verdict issue and what type of instructions are going to need to be given to the jury. And I'll put both parties on notice that I can see that potentially being an issue. So the motions are both denied. Mr. Vervaeten, would you do it in order consistent with this opinion?
Yes, Your Honor. Thank you.
And was there anything else that still needed to be addressed today, Ms. Perrin?
Your Honor, I just wanted to clarify. So your order is saying that for probable cause purposes, you're saying that the state does not need to allege what substance the defendant is under the influence of.
Yes. All they have to do is allege that they're under the influence of something that would fit as an intoxicant, a controlled substance analog, a combination thereof.
Okay, and could I also just inquire of the state if the state, since their experts are here, if the state has destroyed the evidence, the blood evidence?
I guess I wouldn't characterize that as the state destroying the evidence. The policy of the Wisconsin State Laboratory of Hygiene is that a sample will be saved or retained for 6 months. If there's no request for additional testing, then it is not kept any longer. And that's what happened in this case.
Okay, thank you.
All right. Anything else, Ms. Perrin?
No.
Anything else, Mr. Vervaeten?
No, Your Honor, thank you.
All right. I think that's it for today.
Could I update my address?
Yeah, we should update your address and your phone number, make sure we have the right one. And let me just say, Ms. Bender, we've got, I guess I don't have a phone number for you. Oh, I do. Oh, no, I don't. Go ahead, give us your phone number first.
Okay, my phone number is 715-685-8640.
Okay.
And then my address is 1779 James Avenue West, St. Paul, Minnesota, 55105.
And I just want to remind you, Ms. Bender, you've got to keep us informed of current address, whether you have a court hearing or not, and at least let your attorney know to let us know. The issue becomes when we send out notices, if you don't appear, there can be warrants issued for your arrest. It's also always a condition of bond that you keep the clerk of court's office updated with the current address. I've never ever seen it charged, but it's just one of those things where it's in your best interest to keep us all informed of where you're at, okay?
Okay, thank you. Sorry.
So I just want to let the next court date we have is a final pretrial conference on March 4th at 1 o'clock.
Thank you.
All right. You got that, Ms. Bender?
Is there something on January 8th too?
January 8th, the state has to provide an amended information. So that's not a court hearing.
Okay.
And I think, Madam Clerk, have you gotten everything?
Okay, thank you.
Yes, I did get her address, 1779 James Avenue West, St. Paul, Minnesota, 55105.
Okay. I think that's it for today. Thank you.
Thank you.
Thank you.
Thank you.